Okay. So these amendments outline specific regulations and penalties relating to, is this the one? Surrogacies? Yes, in relation to surrogacy services and the abandonment of children conceived through surrogacy. It emphasises the importance of protecting the rights and well-being of children through surrogacy arrangements and imposing consequences for individuals who abandon such children. The references to the Oviedo Convention, an international treaty aimed at protecting human rights in the field of biomedicine, underscores the commitment to upholding ethical principles and safeguarding in surrogacy practices. By aligning with the standards set forth in the Oviedo Convention, the legislation aims to ensure that surrogacy services are conducted in a manner that respects the rights and dignity of all parties involved, particularly the children conceived through such arrangements. The provision imposing penalties on individuals who abandon children after availing of surrogacy services serves as a deterrent against negligent and irresponsible behaviour that could harm the child or birth mother's well-being. By prohibiting such individuals from entering surrogacy services again, the legislation seeks to prevent further occurrences of child abandonment and hold accountable those who fail to fulfil their responsibilities as parents. The delineation of fines and potential imprisonment for offenders reflects the seriousness of child abandonment in the context of surrogacy and underscores the legal consequences faced by individuals who violate these regulations. By imposing both summary convictions and convictions on indictment options for penalties, the legislation provides a range of consequences based on the severity of the offences and aims to deter individuals from engaging in actions that could harm children born through surrogacy. Overall, this amendment underscores the legislative commitment to protecting the rights of the child born through surrogacy, preventing child abandonment and holding accountable individuals who neglect their parental responsibility in the context of surrogacy arrangements. By combining legal penalties with ethical standards rooted in international conventions such as the Oviedo Convention, the legislation seeks to create a framework that upholds the well-being and integrity of children conceived through surrogacy services. I'll let my colleague in if he...
Yeah. I'm happy to just hear what the Minister has to say to the amendment.
Mr. Donnelly.
Gormagat Cahirlock, and I'd like to thank the Senators for submitting the group of amendments. In relation to Amendment 1, I wouldn't agree with the premise that the adoption application involving a child who is not genetically related is exactly the same as a surrogacy application involving a future potential child who will be genetically related to at least one of the intending parents and possibly both of them. I'm satisfied that we have the balance right as regards the safeguards in place and the requirements to be met by the intending parents as part of the dual approval system for domestic surrogacy in order to best protect the rights and welfare of all parties involved. Amendment 4 would simply duplicate within Section 16 the requirement which is already in Section 17 in relation to AHR treatment not being provided unless the provider is satisfied that there is no potential significant risk of harm or neglect to the child. In respect of Amendment 10, Section 59(2) makes clear that a surrogate mother has the same rights as any other woman in relation to her pregnancy. These include the right to manage all aspects of her health during the pregnancy, and it is not considered necessary to specifically refer to termination of pregnancy here, while the stipulation in Section 26 that any woman shall, as standard practice, only be offered a single embryo transfer also applies to surrogacy cases. On Amendment 11, the intending parents must have received appropriate counselling and legal advice prior to applying for approval of a surrogacy agreement. In addition, Section 56(4) provides for the intending parents to give an undertaking that they shall take all necessary steps to provide care and ensure the welfare of any child born as a result of the agreement, and also that they will apply to the courts for a parental order in respect of that child. Amendment 12 seeks to ban single men from accessing surrogacy. This would be unacceptably discriminatory. It's important to note that a single male applicant would have to be genetically related to the child and have to satisfy the regulatory authority that they meet all of the criteria before their application were approved. Amendment 13 makes an interesting proposal in respect of life assurance. We have looked at issues in respect of life assurance and health insurance in the context of surrogacy. However, it was deemed to be too prescriptive to include such a requirement in primary legislation. Obviously, it's open to intending parents and surrogate mothers to agree between themselves to make arrangements in these kinds of areas. As regards guardianship of children born through surrogacy, Section 7 of the Guardianship of Infants Act 1964 provides that a parent may appoint a guardian to be a guardian of the child in the event of that parent's death. Such a guardian is a guardian appointed by a person in their will. In circumstances where a child has no guardian, it's possible for the District Court under Section 8 of the 1964 Act to appoint a person to be the child's guardian. While it would be preferable for any parent of a child to appoint such a guardian, the existing legislation does not require parents to do so, and I would not propose to impose a requirement on parents of children born through surrogacy in relation to such guardianship that is not required of other people who become parents in other ways. Amendment 14 proposes that only countries listed by the OECD and the DAC can be considered for classification as approved through surrogacy jurisdictions. However, as the relevant section, Section 52, relates solely to domestic surrogacy, this proposed amendment would not make sense being inserted where it is proposed. In relation to the final amendment in the grouping, Amendment 15, I believe that the offences provision in the bill in relation to surrogacy and the requirement for intending parents to get preconception approval from the regulatory authority adequately deals with the concerns raised here by the senators. In particular, it's envisaged that any issue related to previous offences against children or women would be discovered through the safety of the child assessment, and as such I am not in a position to accept the amendments.
Thanks, Mr. Donnelly.
In relation to that particular section, Minister Donnelly, in relation to 15, very disappointed that you won't accept that amendment. I mean, and this applies not just to men, but also to women. I mean, as a foster parent over the years, I can tell you that, you know, sexual crime against children is not exclusively to men, it also is to women. And I'm really, really disappointed that you won't accept that. And actually, it's very disturbing that you won't accept that, particularly someone that's been convicted of a crime against a child. Very disappointed. So, you know, if you are trying to maintain public trust and confidence in surrogacy services, it requires adherence to strict regulations and standards that prioritises child protection and safety. So by implementing restrictions on individuals convicted of child sexual offences, it demonstrates, you know, a commitment to upholding these principles of promoting transparency in surrogacy practices. Children born through surrogacy are among the most vulnerable individuals in such arrangements. By prohibiting individuals convicted of sexual offences from participating in surrogacy, it helps protect these children from potential harm or exploitation. Allowing individuals with a history of sexual abuse to participate in surrogacy increases the risk of abuse or harm to children born through the arrangement. This restriction serves as a preventative measure to reduce the likelihood of such risks and prioritise the safety and well-being of the child. So upholding ethical standards and legal regulation in surrogacy is essential to ensure the integrity of the process and to protect the rights of all parties, and that includes the child, Minister. So prohibiting individuals convicted of sexual offences aligns with these standards and reinforces whatever ethical principles are there, but surely there must be some ethical principles there of surrogacy. Surrogacy should put the best interest of the child, ensure the safe and nurturing environment for their upbringing. By excluding individuals with a history of child sexual offences from participating in surrogacy, it reflects a commitment of safeguarding the child's welfare and promoting a supportive and healthy family environment. In conclusion, the prohibition against individuals convicted of child sexual offences participating in or availing of surrogacy service is a crucial safeguard to protect the interests and well-being of children born through surrogacy. By prioritising the child's safety, legal and ethical standards and preventing measures, this restriction helps uphold the integrity of the surrogacy arrangements and ensures a supportive and secure environment for the child's upbringing. So I'm really disappointed, Minister, that you wouldn't accept this amendment, or that some safeguarding is not there for people that may have been involved in and may have committed a sexual offence against a child, that they would not be precluded from this legislation. I'm very, very disappointed, to tell you the truth.
I'm speaking to Amendment 21, but I accept the point that it is related to the current amendment. So Amendment 21 which is Senators Keogan and Mullen have tabled, which would essentially say that the mother identified in the parenting order is not the genetic mother of the child, the father identified in the parenting order is not the genetic father of the child. Essentially, my interpretation of where the senators are going with this is to preclude any transgender person from availing of surrogacy. That appears to be the intention. And I guess Senator Mullen is asking directly that question. The very clear answer is yes. Somebody who is transgender will have full rights to avail of surrogacy, as will anybody else. I simply disagree entirely with the proposition that, as a society, we should say a woman on her own can raise a child, but a man on his own cannot raise a child. I fundamentally disagree. I think for me, it's an extraordinarily offensive proposition. It really is. There are men all over Ireland raising children on their own, be it through separation or divorce or bereavement. And they are exceptional fathers, exceptional men. I would find it extraordinary that we would say men can't raise children, or we shouldn't entertain at the start of a family the idea that a man shouldn't be allowed to have a child, but that a woman can, of course, and women do. I would just fundamentally disagree, Senator, with that proposition. You know, it's an interesting one. You talked about women's rights and being a defender of women's rights at one point in your contribution. I would disagree with that characterization of your involvement in this, I have to say. We've had debates on this, we've had debates on safe access zones. My observation is that you work very hard and very diligently to deprive women of their rights, particularly around fertility. Maybe you do believe that you're here defending women's rights. I certainly don't see it, I have to say. But when it comes to a single man who wants to have a child or children, and surrogacy is the only option available to them, we're accepting it for a woman on her own. As somebody who is pro-life, you know, surrogacy creates more life. It creates more children. It creates more families. It creates more mums and dads. You know, I would have thought that people who are pro-family, pro-life, indeed we're all pro-family, well, it depends on one's definition, I guess. It depends on one's definition. I've rarely met anyone who's anti-life, but surrogacy creates more children who otherwise wouldn't exist. It creates more mums and more dads, and it creates more wonderful families. That's what it does. And whilst I have taken great exception to your characterization around the pro-life debate, I absolutely respect everyone's view on termination of pregnancy across the spectrum. I disagree strongly with you on your characterization of it, but I fully respect everybody's position on that. But I would have thought people who are vehemently opposed to termination of pregnancy, which is a position I don't share but I respect, would be in favour of more children and more life and more mums and more dads and more families. I would have thought. And I appreciate that there is an ideological position, and I appreciate there are some religious institutions who've taken a very public view, and that's fine, and that's fine. But certainly for me, to the Senator's questions directly, can a transgender man or woman under this bill they will have the same rights as everybody else. Can a man raise children in a wonderful, caring, loving way? Yes, he can, and yes, they do, all the time, all over our country. And surrogacy, I think, there are safeguards we have to put in place. It's what this bill spends a lot of time doing. But what an extraordinary thing, what a wonderful thing for one parent or two parents who have tried to conceive naturally and haven't been able to. And maybe then they've tried assisted human reproduction, maybe they've gone through IVF. You know, they'll have practically bankrupted themselves just trying to have a child. They will have gone through potentially rounds of IVF, which is so difficult for them. It is so hard for people going through IVF. And having done all of that and still not had a child, what an extraordinary gift surrogacy can be, so that these incredible women and men can be incredible parents and raise the most wonderful, beautiful children. So I hope that answers the questions.